Your name, sir?
Joseph Fonville.
Thank you. Okay, what are we doing?
Your Honor, I'm asking for an adjournment as I'm awaiting discovery. I was just appointed to this on Thursday.
During this matter to January 8th, 2026, 9 a.m. Bond continued. All right, thank you.
A routine bond hearing quickly escalates as the court reviews multiple criminal cases involving theft, fraud, and drug offenses. With bond decisions and guilty pleas on the line, every ruling will determine whether the defendants leave the courtroom or remain behind bars.
Your Honor, may I make a...
I'm sorry?
I was asking for to make a bond argument, but
Oh, okay, he needs to come back up then. Go ahead, briefly.
Your Honor, Mr. Fonville is in jail on retail fraud. From the written discovery that I have, there seems to be some confusion as to whether it was him or not, and I'm asking for a nominal bond on being that it was a non-assaultive offense.
People would object. The confusion around whether it's him or not was because he's allegedly using his brother's name while he was committing this string of retail frauds. There is an additional retail fraud charge that I am reviewing right now. In fact, I was just given the video for that moments ago that I'll be reviewing. It looks like him and another brother of his continually go in and out of different stores in the area and steal whatever they want. Mr. Fonville has an incredibly long criminal history with dozens of retail frauds dating back decades, in addition to long stints in prison for other theft crimes. He's held on a multitude, at least he was held on a multitude of cases. I don't have ex-jail up, so I can't make that representation accurately at this moment, but the people would object.
Motion for bond reduction denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case. People versus Dion Baldwin.
Mr. Skinner, would you please state your name for the record?
Dante Xavier Skinner Jr.
Thank you.
Yes, sir.
And Your Honor, we would like to set this for exam, and I would like to address bond if the court would allow.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 6. Preliminary examination in this matter will be set January 6, 2026, 9 a.m. That's before Judge Perry. As to bond.
Your Honor, my client is currently on a tether from Wayne County, so he'd indicate to the court that he's not a flight risk. He would like to go live with his mother in Inkster, and his community ties through his parents make him not a flight risk. I'd indicate to the court he has a job as a forklift operator at Ford, and he has a bit of a side hustle doing lighting projects for Smart Lighting Solutions. And I'd also like the court to know the police report indicates the phone in question was his property. So at least on the felonies, we don't think there's much of a likelihood of conviction. So Mr. Skinner would ask the court to tether him to his mother's house in Inkster. He will.
What are the numbers on that address? I don't need the street, but on mother's address.
I'm gonna give it to you.
Go ahead.
27036.
It's not on Oakwood,
No. No.
because I have a no-go to an Inkster, but I don't. All right.
No.
Anything else?
No, that's it.
Mr. Skinner failed to appear back, and at the time he failed to appear, there was a bond violation for him cutting off his tether. The tether was not recovered, and I believe Community Corrections stated they thought it was possibly thrown in the Huron River. So I do think.
Yes, I do see.
He also has a holdout of Wayne with bond denied for an assault. He has a holdout of Garden City for $500 for an RNO. He has a holdout of Lapeer with bond denied for fraud, and he has a holdout of Oakland for stolen property with bond denied. So at this.
Where's our tether?
Your Honor, I honestly think there may
You know? Where's our tether?
Oh.
No, that's Wayne County's.
You should answer that. That could implicate you in something. Why don't you not answer
He
that?
was out with a tether, it was on his leg, and now there isn't a tether. And I'm just asking where the tether is, and you want me to let him out? He doesn't have to answer it. Motion for bond reduction denied. Bond will continue. Thank you.
On an eighth of the head.
I just want to Tether. It's a simple question.
St. John, who is standing to my right,
Your name, ma'am?
I do believe, well, Ms. St. John, would you state your name for the record? Your attorney's just next door. and
Bonnie
cover for
St.
it.
John.
I
I
believe.
have a plea form. Is that what we're doing?
Yes. This was worked out by my colleague Q. He's next door, but I believe I can. St. John, if you want to go ahead with the plea, you can just sign your name on the advice of rights form.
While she does that, the plea indicates that she's going to be pleading to a use of cocaine. The 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. The prosecutor and defense agreed to a sentence of 7411 if she's eligible. That's the court's full understanding of the agreement.
Yes, Your Honor.
Is that your understanding, Ms. St. John?
Who, what now?
That you're going to be pleading to use of cocaine, the 1-year offense.
Do I have to stay in jail for a year?
No, that's the maximum penalty.
Okay,
Okay, I don't know what your sentence would be, but that you'd be pleading to that. That's an added count 2. Then count 1 would be dismissed, which is the felony charge. Okay, and then the form indicates that the prosecutor and defendant have agreed to a deferred sentence status under section 7411.
what's that?
Okay, was that explained to you by your attorney and what that means?
Mm-mm.
Okay, then I'm not taking it.
Could we just pass the matter and call it back later today?
Can I get out of jail today?
Okay, listen, I can't do anything and they're going to have to get her back down. So if that hasn't been explained, I don't know. What I will do, counsel, is I'll do this. I won't put her over into the new year. I'll put her to next week.
Mm-mm, I went out today.
Mr. Well, our assigned PD is right next door, Your Honor, with the court.
I know, but how many more do you guys have back there? Couple? 4? Okay, somebody better explain everything. I'll have her taken back, but if you guys aren't ready when it comes back, I'm gonna be very angry because all of this should have been explained to her.
I will personally.
All
do it,
right,
Your
go
Honor.
ahead. You can take her back, bring me the next one. Court does call the case, people of the state of Michigan versus Bonnie Sue St. John.
Austin Lopez on behalf of Ms. St. John.
The hearing reaches its turning point when Bonnie Sue St. John admits under oath that she possessed and used cocaine. That sworn admission provides the factual basis for her guilty plea, allowing the court to accept the plea and move the case towards sentencing. The judge accepts the guilty plea, dismisses the remaining felony count, and orders a pre-sentence investigation before sentencing.
Can you say your full name for the record, Bonnie?
Bonnie Sue St. John.
I have before me a plea form that indicates that the defendant is going to plead guilty to, well, I don't know how she's gonna plead. I'm presuming it's guilty.
Correct, Your Honor.
Form wasn't checked. She's gonna plead guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration. Upon her successful plea to that charge, count 1 would be dismissed. There's a sentence agreement that the defendant would get 7411 if otherwise eligible. As I indicated before, that's a full extent of the agreement as the court understands.
That's correct, Your Honor. That's correct. Reflection of the agreement.
Did we get her sworn or no? We never even got that far. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Bonnie Sue St. John.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes.
Yes, sir.
Still wish to plead guilty?
Yes.
Yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes,
Any question regarding any of those rights? No?
no,
Look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
mhm,
Yes.
yes,
You understand you're giving up your right to appeal of right.
mhm, yes,
Are you on probation?
no,
Are you on parole?
no,
Has anybody promised you anything other than what's been stated here today to get you to plea?
no,
Has anybody threatened you or coerced you?
no,
You're doing this voluntarily
yes,
and of your own free will,
yes,
and because you believe that you are indeed guilty of this offense?
yes,
On the date of April 21st, 2025, at Montneer Ridge Road in Superior Township, Washtenaw County, State of Michigan,
Mhm.
did you have cocaine in your possession?
no,
Okay, did you use cocaine?
the day before,
Okay, let's do it this way. On or about, which may be the day before, maybe the day after, April 21st, 2025, did you have cocaine in your possession?
yes,
Had you used it?
the day before,
Yes.
mhm,
He wants you to say yes.
yes,
So on or about that date, you had used cocaine
yes,
and you knew what you were using was cocaine.
yes,
All right. Ma'am, I do have to advise you that if between the time I accept your plea and your time of sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to, well, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
yes,
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
People are satisfied.
Defense is also satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be January 20th, 2026. Really? Really? No, you can't get back. 2026, what time? 10 a.m. before Judge Barr.
Your Honor, I'll note one thing, there seems to be an extra 4 on the statute number for use of controlled substance. I apologize for the typo, 74042B. Just an extra one protected there.
Oh, it should not be 4-4.
It should not be 4, just 1 4. If there's no objection from defense counsel, we may want to change that.
No,
I did change. Okay, good. All right, good enough. All right,
Your Honor, may I address bond?
you may.
Your Honor, my client is asking for a PR bond at this time while she waits her sentencing. Due to this charge being a misdemeanor, I don't believe that she's a further to the community nor a flight risk. She just wants to be with her family for Christmas, Your Honor.
In response from the people.
Leave it in expression for.
hmm. 30 days,
Well, part of the reason she's in is she was using cocaine.
clean now,
Well, yeah, because you've been in jail and we don't let you do that there.
but I'm gonna be taking methadone.
So what do you mean you're going to be taking methadone?
For my doctor,
Did you have another type of substance abuse problem?
just cocaine. Mhm, at home.
So were you in treatment before?
Going through my doctor.
Okay, but when's the last time you saw your doctor?
I do it through the phone.
Okay, if you do it through the phone, let's just go with that. When's the last time you did that?
I talk to her all the time.
Remember the last time we spoke to her?
All right, here's what I'm gonna
My
do.
actual,
Real easy. I'm not entirely saying no, but I'm gonna leave it up to. I have no objection if after she speaks with.
I'm supposed to go see
Okay.
her when I get out of here. Go to her office at 8 Mile in Farmington.
But listen real close. I'm not necessarily saying no.
She also previously had treatment set up at Gretchen's place in Belleville, and she was gonna be due to enter there before she got picked
When?
up. In late November. Before she got picked up.
In late November.
Yeah.
Day before I got
Mhm.
picked up.
That's right, because she basically was warranted because of her use. I'm gonna have Judge Barr's probation department take a look at it before I do anything in terms of her release. So at this time, I'm gonna deny the defendant's request for a bond reduction. And then let probation look at it and present it to Judge Barr regarding her release.
Understood.
Thank you. Bond.
But the request for release is denied, leaving the defendant in custody while probation reviews her case, an outcome that underscores how treatment considerations in public safety can outweigh a request for bond.